All right, now judgment has been reserved in the Western Cape High Court matter dealing with the VAT hike just 8 days before the 0.5 percentage point increase is due to kick in. The court made an undertaking that it will come back to the affected parties by the 29th of this month. The Democratic Alliance, as well as the Economic Freedom Fighters, took their battle against the VAT rise to court, saying Parliament erred in its decision to adopt the Fiscal Framework Report, which paves the way for the increase. Now, both parties argue the increase would have a dire impact on already struggling consumers in South Africa, while the EFF is seeking temporary relief to suspend the pending VAT hike. The DA argued that Section 74 of the VAT Act gives the Finance Minister too much power. Lawyers for Finance Minister Enoch Godongwana disagree. Parliament's lawyer says the institution followed all due process which led up to the vote in favour of the adoption of the Fiscal Framework Report on the 2nd of April. Now, to talk about the DA's legal challenge against the VAT, we're joined by its national spokesperson, Karabo Khachau. Good evening, Karabo. Thank you very much for joining us on the program. So today, your urgent matter was indeed, on the VAT hike, was indeed heard. Just talk us through the main argument around the procedural irregularities that you maintain took place at the committee meeting ahead of that budget vote.
Dumela Osumfundo, thank you so much for having me, and good evening to your SABC viewers. So the procedural irregularity that we've identified as the Democratic Alliance has to do with the 1st of April Fool's Day committee meeting that took place at Parliament, a joint committee meeting, the Select Finance Committee of both houses of the National Assembly as well as the National Council of Provinces. You'd know that the mandate of that committee would have been to consider the fiscal framework, either to put a stamp on it, to approve it as is, or to make an amendment to it. So as for the question on whether or not the fiscal framework is going to be adopted or not, the question there from the chairperson remains naked, and the process to be followed clearly, for as far as the members of that committee is concerned, is still a question mark. So there was confusion altogether on what was considered. But also you would know that the draft committee report that was considered in that meeting is not the same report that was tabled before Parliament, particularly because post the adjournment of that meeting, there were amendments still that were made to the report, which meant that the final version was not voted for by that committee, and that consideration didn't take place. So ultimately, then the tabulation of a committee report that served in both houses of Parliament, the National Assembly and the National Council of Provinces, was not that which was voted for. So the basis upon which these two houses voted for the fiscal framework, or the consideration of the report, was flawed. And that's part of the problem that we had.
Karabo, I want to come back. Pardon me for interjecting there. I'm going to come back to the final version that was voted on, but I just want to take you back to the other aspects that you were challenging, which are the Finance Minister's powers. Just talk to us about just that specific one.
So the Democratic Alliance is of the firm belief that the powers are in breach of the Constitution, that there's a constitutional irregularity there. So the current provision of Section 7.4 of the VAT Act empowers the minister to make a declaration on a VAT increase without the consideration of Parliament. The reason why we're saying that this is a problem is because there is only one house that has one house of the three spheres of government that has the constitutional power to impose taxes for revenue collection. And that arm of state is the legislative arm of state. Nationally, that is Parliament. Provincially, that is the provincial legislatures. Locally, it is the municipal councils. It is not the executive. However, the way Section 7.4 of the Constitution is currently written gives an executive arm of state, which on a national level would be the minister, provincially the MEC, and on the local level the MNC, the power to do so without the consideration of Parliament. And we're arguing that this is wrong. We do have a case study of a case that was before court before, that was ruled on, that proves that we are right. The example there is quickly of the West Province in the past, where there was a case with the then MEC as well as the Casino Association, where the Casino Association mandated the MEC to tax the people of that province
Karabo, then now to that final version
Money
of
for
the
revenue collection. And the court upheld that this is wrong. Because
Pardon me, I just couldn't hear you there for a moment. But then to the final version of the report that was presented before Parliament, and more specifically the inclusion of those non-binding recommendations of the 30 days to come up with alternative revenue sources. In his affidavit, in his answering affidavit, the Finance Minister says he has never suggested that he could revoke the implementation of the VAT increase as it stands right now, which to us almost suggests that the Action SA non-binding recommendation to come up with that alternative revenue source was never going to work.
that is true. So that's why we've maintained that Action SA remain the April Fools of the year, particularly because there are only two processes that can be followed to amend the fiscal framework or to revoke it as it currently stands. One, the Finance Committee would have to, in the Select Committee of Finance would have to amend the fiscal framework, which they did not do in this case. Or two, there would have to be an opposing act that needs to be proposed by Parliament to judge against the act of a VAT increase altogether. So that did not happen, and that's why our argument was clear, that recommendations are not legally binding. So when Action SA in committee said that they are in favor of the fiscal framework on condition that there's no VAT, that meant nothing. All that meant was that the minister had to note and then flip the page and move forward altogether. It had no binding. But while my network was against me, what I was arguing earlier before I got cut off was that the case of the court.
Oh, Karabo, we're losing you there again. Unfortunately, we have lost Karabo. A very important conversation we were having there. My last question would have been around also Action SA's very scathing statement yesterday, where they've gone on to state that as far as they know or have established now, that the Deputy Finance Minister, who's a Democratic Alliance deployee, was very much a big part of the putting together of the budget, be it the first 2% and then the revised 0.5%. So as many would have seen that statement yesterday, Action SA says now they're feigning ignorance, or at this point when it suits the Democratic Alliance, they believe that they want to stand on the side that says they're absolutely against the 0.5%, whereas it was something that they've known for quite a long time, but they seem to have been negotiating on peripheral matters that didn't have to do with the budget currently, and that's probably why they didn't get their way. But as they've maintained that they were more than willing perhaps to accept the 0.5 percentage point VAT increase. But unfortunately, we have lost Ms. Khachau there. But she stated basically the gist of that argument that we heard today in court. That was National Spokesperson Karabo Khachau speaking to us on their legal action supported by the economic freedom fighters as well.